Every time you clock in for a shift or scan your pay stub, you are relying on a fundamental floor beneath your feet, a legal guarantee that your time is worth at least a specific, non-negotiable amount of money. But that invisible safety net is a shocking historical anomaly. The United States had no federal minimum wage until 1938. Before that year, the very concept of a government telling a business owner the lowest legally permissible amount they could pay a worker was considered a radical, even unconstitutional, infringement on liberty. So what did bosses actually pay before the law forced their hand? And how did a system built on absolute employer dominance finally break? This is not just a story about dollars and cents. It is a story about the raw mechanics of power, the brutal realities of unregulated capitalism, and the desperate, decades-long fight to establish a baseline for human survival in the industrialized world. To understand the magnitude of what changed in 1938, we have to step back into the engine room of the American Industrial Revolution. In the late 19th and early 20th centuries, the American economy was expanding at a blistering, unprecedented pace. Millions of immigrants were pouring into coastal cities, while millions more rural Americans were leaving agricultural lives for the promise of factory wages. But stepping onto a factory floor meant entering an environment where the employer's authority was absolute. The prevailing legal and economic philosophy of this era was anchored in a doctrine known as freedom of contract. On paper, it sounded like the ultimate expression of American liberty. The highest courts in the land repeatedly ruled that an adult worker and an employer had the absolute right to negotiate the terms of employment without government interference. If a factory owner offered 10 cents an hour and a desperate worker accepted it, the legal system viewed this as a perfectly fair, voluntary agreement between two equals. The reality, of course, was vastly different. There was no true equality of bargaining power between a massive, well-capitalized industrial trust and a starving laborer who needed to feed their family that evening. Because there was no legal wage floor, compensation was determined entirely by the ruthless mathematics of supply and demand. If 100 men were waiting outside the factory gates begging for work, the foreman could simply lower the wages of the men currently working inside. If they refused the cut, they were replaced instantly. In many of the most dominant industries, workers were not paid by the hour at all. They were paid by the piece. In the infamous garment sweatshops of New York and Chicago, women, young girls, and newly arrived immigrants earned mere pennies for every shirt collar or hem they stitched. This piece rate system weaponized their own desperation, driving them to work 14 or 16-hour days in dark, poorly ventilated rooms just to afford rent in crowded tenement slums. There was no overtime pay, no weekend rate, and no guarantee that a full day of exhausting labor would yield enough money to buy dinner. In more isolated sectors, the situation resembled outright feudalism. In the coal fields of Appalachia and the logging camps of the Pacific Northwest, employers frequently bypassed the United States dollar entirely. Miners and timber workers were often paid in company scrip, a private, unregulated currency minted by the employer and valid only at the company-owned store. Because the company held a monopoly on essential goods in these remote towns, they routinely inflated the prices of food, clothing, and mining tools. A worker could toil deep underground for 60 hours a week, only to find that their scrip earnings were perfectly calibrated to leave them in debt to the company store at the end of the month. The boss did not just control the wage, he controlled the cost of living, effectively trapping generations of workers in a cycle of debt peonage from which it was nearly impossible to escape. During periods of economic stability, this system generated unprecedented wealth for the industrial titans of the Gilded Age. But during economic downturns, the absence of a minimum wage created a devastating, society-wide downward spiral. When demand for manufactured goods fell, factory owners did not just lay people off, they aggressively slashed the wages of those who remained. Competitors would then slash their own wages to keep their prices low, initiating a vicious race to the bottom. This created a paradox that terrified social reformers and labor organizers: the phenomenon of the working destitute. Entire populations of people were laboring continuously, contributing to the nation's industrial output, yet still starving and freezing in the shadow of the factories they operated. Poverty was not a symptom of unemployment. It was the guaranteed mathematical outcome of employment under a system with no floor. The mounting tension between immense corporate wealth and grinding worker poverty began to spark violent labor strikes, threatening to tear the fabric of the nation apart. The question was no longer if the system was sustainable, but who would have the power to finally force a change. The pushback against this system of absolute employer control did not begin in Washington. The federal government, constrained by a strict interpretation of the Constitution, was viewed by both politicians and the public as having no jurisdiction over local manufacturing conditions. Instead, the first cracks in the doctrine of unregulated wages appeared at the state level, driven by a coalition of progressive-era reformers, settlement house workers, and early labor advocates. But these reformers faced a massive legal blockade: the Supreme Court's rigid defense of the freedom of contract. To circumvent this, they had to find a legal loophole, a demographic that the courts might concede required the protective intervention of the state. They found it in women and children. Because the legal establishment viewed adult men as independent actors, fully capable of negotiating their own terms, reformers argued that women and minors lacked this inherent bargaining parity and were therefore uniquely vulnerable to industrial exploitation. This paternalistic legal strategy yielded the nation's first minimum wage law in Massachusetts in 1912. However, a close examination of the Massachusetts statute reveals just how terrified lawmakers were of angering business interests. The law did not establish a mandatory legal floor. Instead, it created a wage commission empowered only to investigate industries and recommend a living wage. If a factory owner refused to pay the recommended rate, the state could not fine them or shut them down. The only penalty was having the company's name published in local newspapers. It was a system reliant entirely on public shaming, a remarkably weak weapon against industrial titans who already operated with ruthless efficiency. Despite its lack of enforcement power, the Massachusetts experiment inspired a wave of similar legislation. Over the next decade, 14 states and the District of Columbia passed their own minimum wage laws targeting female and child laborers. Some of these newer laws actually carried legal weight, penalizing employers who pay below the state-mandated survival line. For a brief moment, it appeared that the absolute authority of the boss was being successfully challenged. But the corporate counterattack was swift, well-funded, and aimed directly at the highest court in the land. The decisive showdown arrived in 1923 with a Supreme Court case known as Adkins versus Children's Hospital. The dispute centered on a Washington, D.C. law that established a minimum wage for women. A children's hospital, relying on cheap female labor for its cleaning and support staff, sued to block the law, arguing it violated their constitutional right to freely negotiate contracts. The Supreme Court's ruling sent shockwaves through the American labor movement. Writing for the majority, Justice George Sutherland struck down the minimum wage law as entirely unconstitutional. In a twist of legal irony, Sutherland cited the recent passage of the 19th Amendment, which granted women the right to vote. He argued that because women now possessed political equality, they were legally equal to men in the marketplace and no longer required the special protective legislation of the state. Therefore, denying a woman the right to accept a starvation wage was an unconstitutional infringement on her liberty. The Adkins decision was catastrophic for the working poor. It effectively outlawed the minimum wage across the United States. State after state saw their wage boards dissolved and their labor laws invalidated by lower courts, citing the Adkins precedent. Employers, suddenly freed from the looming threat of state regulation, immediately rolled back pay rates. In the garment industries of New York, in the textile mills of the South, women who had briefly seen their paychecks stabilize at a meager but predictable level were plunged back into the chaotic, piece-rate desperation of the previous century. Throughout the roaring 20s, the underlying fragility of this unregulated labor market was masked by an explosion of consumer credit and superficial economic booming. Industrial production soared, but because there was no mechanism to ensure wages kept pace with productivity, the wealth generated by this boom became hyper-concentrated at the top. The workers producing the automobiles, radios, and appliances could rarely afford to buy them without taking on dangerous levels of debt. The American economy was operating like an engine running without oil, generating immense heat and speed, but fundamentally tearing itself apart from the inside. When the stock market collapsed in October of 1929, the absence of a minimum wage transformed a severe financial crisis into an unprecedented humanitarian disaster. As consumer demand evaporated, the old vicious cycle of wage slashing returned, but this time on a national scale. Employers cut pay relentlessly to stay afloat, which further destroyed the purchasing power of the American public, causing demand to drop even further. By 1932, desperate men and women were accepting wages of 5 cents an hour just to secure a place in a breadline. The theoretical arguments about the freedom of contract meant nothing to a population facing mass starvation. The unregulated labor market had failed spectacularly, pulling the entire nation into the abyss of the Great Depression and setting the stage for a political confrontation that would finally break the absolute power of the American boss. The election of Franklin Delano Roosevelt in 1932 represented a fundamental shift in the American public's tolerance for unregulated economic suffering. Roosevelt entered the White House facing a shattered nation. With unemployment nearing 25%, his administration understood that the catastrophic collapse of wages was not just a symptom of the Great Depression, but the very mechanism driving it deeper. To restart the American economic engine, they had to restore purchasing power to the working class. And that meant the federal government had to do something it had never successfully done before: dictate the terms of employment to private businesses. In 1933, Congress passed the National Industrial Recovery Act, or NIRA, a cornerstone of the early New Deal. The NIRA was an audacious, highly experimental attempt to legally cartelize the American economy. Through a newly created agency called the National Recovery Administration, the government worked with industry leaders to draft codes of fair competition. Crucially, these codes established industry-specific minimum wages and maximum working hours. Businesses that complied were permitted to display a prominent Blue Eagle emblem in their windows and on their products, signaling to desperate consumers that they were doing their part for national recovery. For a brief period, the Blue Eagle campaign seemed to work. Millions of workers saw their wages stabilized. In the textile industry, child labor was effectively banned overnight through the code agreements, and adult workers saw their pay bump up to a legally mandated minimum. But the architecture of the NIRA was structurally flawed. Because it relied on industry leaders to draft the codes, corporate monopolies routinely manipulated the rules to crush smaller competitors. More importantly, the federal government was operating on highly dubious constitutional grounds, aggressively stretching the Commerce Clause to regulate local businesses that did not operate across state lines. The corporate backlash was inevitable, and it culminated in one of the most consequential legal battles in American history. The fatal blow was struck in 1935 by a kosher poultry slaughterhouse in Brooklyn. The Schechter Poultry Corporation sued the government, arguing that the NRA codes regulating their wages and hours were unconstitutional because their business operated entirely within the borders of New York. In a unanimous and devastating decision, the Supreme Court agreed. The court ruled that Congress had unconstitutionally delegated its legislative power to the executive branch and overstepped its authority regarding interstate commerce. The NIRA was struck down. The Blue Eagle was dead, and immediately the wage floor collapsed. Within months of the Schechter decision, employers across the country slashed wages and lengthened hours. The agonizing race to the bottom resumed. Roosevelt was furious, viewing the conservative Supreme Court as an archaic blockade against modern economic survival. After winning a massive landslide re-election in 1936, FDR decided to force a constitutional crisis. He proposed the Judicial Procedures Reform Bill of 1937, infamously known as the court-packing plan. Roosevelt threatened to add up to 6 new justices to the Supreme Court, diluting the conservative majority and stacking the bench with New Deal sympathizers. The political fallout was explosive. Congress balked, and the public accused Roosevelt of attempting to establish a dictatorship. But the sheer audacity of the threat sent a chilling message to the judicial branch. And in the spring of 1937, the immovable wall of the Supreme Court suddenly cracked, triggered not by a powerful politician, but by a chambermaid working in a hotel in Wenatchee, Washington. Her name was Elsie Parrish. She had been employed by the West Coast Hotel Company cleaning rooms, but she was paid less than the state of Washington's mandated minimum wage for women. When she was discharged, she sued the hotel for $216.19 in back pay. Under the strict precedent of the 1923 Adkins decision, Parrish's case should have been quickly dismissed. The hotel owners confidently appealed the case all the way to the Supreme Court, fully expecting the conservative justices to once again champion the freedom of contract and strike down the Washington state law. But history pivoted on Elsie Parrish. In a stunning reversal that legal scholars would later dub the switch in time that saved 9, Justice Owen Roberts, who had previously voted to strike down minimum wage laws, changed his alignment. In a 5-4 decision in West Coast Hotel Company versus Parrish, the Supreme Court upheld the Washington minimum wage law, explicitly overturning the Adkins precedent. Chief Justice Charles Evans Hughes, writing for the majority, finally dismantled the absolute sanctity of the freedom of contract. He argued that the Constitution did not protect the liberty to exploit vulnerable workers, declaring that a state had a vital interest in protecting the health and safety of its citizens from the brutal mechanics of an unregulated market. The legal dam had broken. The constitutional path for a federal minimum wage was finally clear, but the political battle was just beginning. The task of drafting a universal, permanent federal wage law fell to Frances Perkins, Roosevelt's Secretary of Labor and the first woman to serve in a presidential cabinet. Perkins had spent her entire career fighting industrial exploitation, having witnessed the horrors of the Triangle Shirtwaist factory fire decades earlier. But forcing her proposed legislation, the Fair Labor Standards Act, through Congress proved to be a grueling, brutal fight. The fiercest opposition came from Southern Democrats. The Southern economy was heavily reliant on ultra-cheap agricultural labor and aggressively anti-union textile mills. Southern politicians openly argued that establishing a national minimum wage would destroy their regional economic advantage, which was explicitly built on paying black workers and poor white farmers starvation wages. To secure the votes necessary to pass the bill, Roosevelt and Perkins were forced to make devastating compromises. They had to explicitly exclude agricultural workers and domestic servants from the law's protections, categories of work heavily dominated by African Americans and women. Even with these massive carve-outs, the fight went down to the wire, requiring intense political maneuvering to bypass hostile committees and force a floor vote. Finally, on June 25, 1938, President Roosevelt signed the Fair Labor Standards Act into law. For the first time in the history of the United States, the federal government had established a universal, mandatory floor for human labor. The law set the first federal minimum wage at 25 cents an hour, mandated a maximum 44-hour work week, and required employers to pay time and a half for overtime. It also strictly banned oppressive child labor in manufacturing, fundamentally altering the architecture of American childhood. When the law went into effect in October of 1938, the immediate impact was profound. Overnight, an estimated 300,000 workers received a mandatory pay increase, and over 1 million saw their grueling work weeks shortened. But while the Fair Labor Standards Act successfully broke the absolute dictatorship of the employer, the compromises required to pass it left millions completely unprotected, setting the stage for a new era of conflict over exactly who deserved the protection of the American legal safety net and what, exactly, a minimum wage was actually supposed to achieve. October 24th, 1938, dawned as a day of quiet revolution across the American industrial landscape. When the factory whistles blew and millions of workers clocked in, the Fair Labor Standards Act officially went into effect. The federal government, once deemed powerless to intervene in private contracts, was now a permanent, invisible presence at every negotiating table, every payroll department, and every factory gate in the country. The era of the absolute dictator on the shop floor had ended. For the first time, a legal floor rested beneath the American worker, constructed of 25 cents an hour and a 44-hour maximum work week. The immediate consequences were profound, but the victory was heavily fractured. For the industrial working class, predominantly white men in northern manufacturing centers, the law was a triumph. It stabilized their incomes, eradicated the downward spiral of wage slashing during economic dips, and provided a foundation upon which labor unions could negotiate even better contracts. The elimination of child labor in manufacturing opened up jobs for adults and fundamentally changed the trajectory of American education, moving children from the textile mills into the classroom. However, the architecture of the law contained deliberate, devastating blind spots. To secure the votes of Southern segregationists, President Roosevelt and Secretary Francis Perkins had sacrificed the most vulnerable workers in the nation. By explicitly excluding agricultural laborers and domestic workers from the Fair Labor Standards Act, the federal government legally abandoned a massive portion of the minority workforce. Nearly half of all African American workers and an overwhelming majority of African American women were left completely outside the protective umbrella of the new law. For them, the brutal, unregulated labor market of the 19th century continued uninterrupted. It would take nearly 30 years of relentless civil rights organizing and subsequent amendments in the 1960s and 70s to finally bring these excluded sectors under the protection of the federal wage floor. Meanwhile, American corporate interests, having lost the constitutional war to destroy the minimum wage, quickly adopted a new, highly effective strategy to neutralize it. They realized they no longer needed to repeal the Fair Labor Standards Act. They simply needed to let time and inflation do the work for them. Because the 1938 law set the wage at a fixed monetary amount, rather than pegging it to the rising cost of living or worker productivity, the wage floor would slowly sink in value every single year unless Congress actively voted to raise it. This structural flaw transformed the minimum wage from an economic baseline into a perpetual political weapon. Throughout the mid-20th century, as the American economy boomed, Congress regularly adjusted the wage upward, allowing the working class to share in the nation's rising prosperity. At its peak purchasing power in 1968, the federal minimum wage was high enough to keep a family of 3 above the poverty line. But as corporate lobbying power intensified in the latter half of the century, those congressional updates became increasingly rare and fiercely contested. By fighting to delay wage hikes, business interests effectively secured a permanent, stealthy reduction in their labor costs, year after year, as inflation quietly eroded the purchasing power of the worker's paycheck. This strategy of attrition brings us to the profound tension of the modern era. Today, the federal minimum wage has remained frozen since 2009, marking the longest period without an increase since the system was created in 1938. In real economic terms, the federal floor has collapsed. A worker earning the federal minimum wage today possesses less purchasing power than their counterpart did 60 years ago. As a direct consequence of this federal paralysis, the battle has fractured and returned to exactly where it began a century ago, the state and local levels. A patchwork of regional wage laws has reemerged, creating a deeply divided national economy where the legal value of an hour of human labor depends entirely on which side of a state line the factory sits. The creation of the minimum wage was not merely an economic policy shift. It was a profound alteration of the American social contract. It answered the crisis of the Great Depression by declaring that a business lacking the ability to pay a survival wage had no legitimate right to exist in a civilized society. Yet the erosion of that system forces us to confront an unresolved philosophical divide that has persisted since the days of the sweatshops. When you look at the architecture of our modern economy, is a minimum wage meant to guarantee a baseline standard of living that prevents poverty? Or is it merely an entry-level stepping stone meant only for unskilled, temporary labor? The systems that dictate our wealth, our time, and our survival are rarely natural occurrences. They are constructed through decades of hidden conflicts, legal battles, and deliberate compromises. To understand the world you live in, you have to understand the blueprints of the institutions that govern it. Subscribe to the channel to continue uncovering the hidden historical architecture behind the economic structures you interact with every single day.